Hi, and welcome to Hull TV. I'm Dana O'Brien, and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull TV, we're exploring the issues around estate planning that affect you. Ian and Suzana, it was Ben Franklin who coined the phrase that nothing is certain except death and taxes. So let's talk about how to plan for those certainties. Ian, let's start with you. What is estate tax?
An estate tax conventionally is understood to be the tax that is paid on your death, and we describe it here in Ontario as a probate tax, specifically tied to your assets at the time of your death.
Are there different types of estate tax?
There are, and depending on where you live, there are different jurisdictions that will impose tax on your assets. But typically, in Canada anyway, we have essentially a provincial tax in most provinces, and then we have the Government of Canada that taxes as well.
And Suzana, what taxes apply when someone dies?
Well, the federal tax that Ian was just referring to is the income tax that we face when there is a deemed disposition on our death of all of our assets. And so if we die owning capital assets that have appreciated in value, then the gain on those assets will be taxed on our death. Similarly, if we have tax-sheltered assets, things like our RSPs or RRIFs, then they're going to lose their tax-sheltered status on death unless you've done some kind of advanced estate planning.
And how do you create an estate plan that's as tax efficient as possible?
Well, the key really is to do some considered prior estate planning, and many times that's done with the assistance of professionals, people like lawyers or accountants or financial advisors, who can help you create some tax deferral or tax reduction strategies. They might suggest things like making charitable bequests in wills, or perhaps using unused RRSP contribution room, or life insurance vehicles that might help fund the tax liability on death.
Ian, the 21-year rule, what is it and what sort of challenges does it create?
Well, it's sort of a mythical rule that is out there in the legal profession and with lay people who sort of hear about this concept and don't necessarily entirely understand why or what its importance is. From our perspective, at its simplest form, the 21-year rule is essentially the federal government's rule that has been created many, many years ago, hundreds of years ago, but the federal government has latched onto it, that allows essentially a termination of how much you can advance plan for. And Suzana has described the kinds of techniques that are used to avoid the 21-year rule, but essentially it's a stopping point. So if you tried to push out your tax obligations beyond your death, they're going to actually kick in to payment at some point, and there's a rule that's called the 21-year rule that sort of locks it down.
Ian, what are some of the solutions?
Well, mercifully, there are solutions, and they are not overly complex for many of us. What usually will happen is that if you want to try to project out and avoid paying tax immediately on your death, then you can create things such as a life interest or extending the time for the payment of the tax by attaching the asset to someone else. Typically, an easy rollover is to your spouse. So you pressed out the last person to die to the point in time of the tax being paid. Reorganizations also occur. So the 21-year rule is a rule, but with every rule there's exceptions. And we, in the estate planning side, are always looking for appropriate and well advised opportunities to avoid that immediate payment of tax even at the point of the 21-year rule, because you might have created so much gain in there that it's going to be a significant number and it may impact your overall assets.
Helpful to know. Ian and Suzana, thank you. And thanks for joining us on Hull TV.